Good afternoon, everybody. We're just giving an opportunity for people to join the webinar now, and then we'll get started. Lots of people pouring in, which is great news. Once the number stabilizes, we'll get started. Okay, so welcome to the second in our bite-sized overview webinar series, which is taking place on 3 Wednesdays across October. This is the second in the series, and what is being dealt with in this webinar today is, as you can see on the screen, local authority interventions in private law proceedings. So the two people that are presenting to you today is me, Rachel Francis, and also Roshni Popli, who's sitting next to me. And we are going to take you through various different points, some of which are contained in these slides and some of which will follow in more detail as we go along. So what are we going to be covering today? We're going to consider, first of all, some of the powers that the courts have to direct an investigation into a child's circumstances, and that may be a one-off or a repeat investigation. And then secondly, the court's power to make public law orders within private law proceedings, and that may be repeat orders, but certainly of a set duration, and we'll come to that shortly. Finally, we're going to be looking at some practical pointers. How might these issues come up in proceedings that you're involved in or proceedings you may be involved in the future? Great. So starting with a quick overview, what we're really talking about is those cases where a court is dealing with a private law application and the court becomes sufficiently concerned about the material, the evidence, that submissions that are placed before it, that it considers that it may be necessary for an intervention from a local authority by way of issuing public law proceedings. And the court, having reached that point in its mind, considers that there needs to be an investigation of a child's circumstances. And what you can see from this case of K, which is referred to at the bottom of the overview slide we're looking at together, is that really this provides what's called a jurisdictional bridge, that being Section 37 of the Children Act 1989, between when proceedings are private and when proceedings become public law proceedings. We're going to come back to the case of K a few times across the 40 minutes that we have together, but that's just an overview for now. So I'm going to hand over to Roshni, who's going to take us through the detail of Section 37.
Thank you, Rachel. Right, next slide. So looking at the statute now. So there's going to be a few slides on the statutes and the provisions. So firstly, subsection 1 of Section 37. So where it appears to the court that it may be appropriate for a care or a supervision order to be made, the court may then direct that local authority to undertake an investigation of the child's circumstances. Now, looking at subsection 2, so where the court makes such a Section 37 direction, when the local authority undertakes that investigation, they need to consider various things. So firstly, whether they should A, apply for a care order or for a supervision order with respect to the child. Secondly, whether they need to provide some services or assistance for the child or his family. And lastly, whether they need to take any other action with respect to that child. So I'll leave that on the screen for a little moment. Now, subsection 3. So where a local authority is undertaking this investigation, and they decide actually not to make an application for a care order or a supervision order, they need to inform the court of certain things. So firstly, their reasons for deciding not to make that application. Secondly, any services or assistance that they have provided to the family or that they intend to provide. And any other action which they have taken or propose to take with respect to the child. I can see there's a raised hand, but I'm going to presume that may have been an accident. And carry on. Okay, so one thing that's important to say, two participants raised their hands. Maybe it's because they have questions. We're going to be dealing with questions at the end, so
yes.
hopefully that will reassure those people with their hands up. Yes, so it's important to state that section 37, the purpose of that section, is not merely to obtain a general welfare report with respect to a child. It's a way that the court can cause a local authority to assess whether or not they think that a care or supervision order is appropriate in this case. So it's not a section 7 report by the back door. Subsection 4. So that information that the local authority need to provide to the court, they have usually a period of 8 weeks, beginning with the date of the section 37 direction, to provide that information, unless the court specifies a different date for that. So which local authority? So subsection 5 states that the local authority that's named in the direction must be either the authority in whose area the child is ordinarily resident, or where the child is not ordinarily resident in the area of a local authority, the local authority within whose area any circumstances arose in consequence of which the direction is being given. So this is similar to the provision in section 31 of the Children Act when looking at which local authority should be designated. Right, looking at subsection 6. So if on the conclusion of the local authority's investigation into the child's circumstances, they decide not to make the application for a care order or a supervision order, they should consider whether it would be appropriate to review the case at a later date. And if they decide that it should be reviewed, they need to set a date for that review on when that should begin. So, reasons. So it's important for the court to spell out its reasons for making the section 37 direction very carefully, and a transcript or a full note of the judgment should be made available to the local authority at the earliest opportunity. That's from the case of M from 2003, that's referred to on the page. This is really important because the reasons are needed to ensure that this direction is actually effective, and so that the local authority is fully aware of the reasons behind the making of the direction. And in many private proceedings where a section 37 direction is made, the local authority may not be involved at all within the private proceedings. They may not know what the concerns are, what's going on with this family, and so detailed reasons ensure that a social worker who is then given the case and has to do the investigation, they can understand the focus of the court's concerns, and they can properly investigate those concerns as part of the report and address them. There is an interesting point in relation to costs that Rachel will speak to you about.
So this is just in relation to the, I mean, it's a bit of alphabet spaghetti, the HB and PB, OB and London Borough of Croydon case that's referred to at the bottom, and that was Mr. Justice Cobb, who was handing down the judgment. It's quite an unusual judgment, a non-party local authority having a cost order made against it. But the point of interest for this webinar and for practitioners dealing with private law proceedings in which a Section 37 direction is made is exactly as Roshni was just spelling out, the need for specificity as to what that investigation is looking at. And one of the problems that had arose in this case that Mr. Justice Cobb dealt with was the local authority had really not got to grips with the issues in proceedings, and they had allocated a social worker who was very junior, not being adequately supervised, and the local authority had not really turned its mind to the detail of the concerns and the kind of substance of the concerns in this case, which included fictitious illness or possible fictitious illness. And as a result, the Section 37 report was wholly inadequate, and it had a knock-on effect of some severity in respect to the proceedings and the effectiveness of hearings that the court had set up. And so a cost order was made against Croydon. So it can be helpful to go to, if you've had an inadequate Section 37 investigation report come back to you, or if you're wanting some direction as to how the court approaches what is adequate and what social workers should or shouldn't be doing when they are presented with this kind of case. And as Roshni rightly pointed out, one where they've not been involved with the family to date and need to be upskilled on what's going on for the children in the family. Great, so I'll pass back to Roshni now.
Thank you. Slide. So yes, repeat Section 37 directions. So the court has jurisdiction to make more than one Section 37 direction during one set of private law proceedings, and also to extend or renew an earlier Section 37 direction if the circumstances justify this. So as a matter of principle, where a judge is satisfied that a local authority has simply just not complied with an initial Section 37 direction, or has conducted an investigation which fails to a significant degree to engage with the court's concerns, then the court does have jurisdiction to extend or renew its Section 37 direction. But in each case, it's going to be a case-by-case issue to determine whether such a course is justified. Now back to this case of K. Lord Justice McFarlane, as he then was, said that in approaching that question, so whether or not it's justified to make a further Section 37 direction or extend one, it will be necessary to bear very much in mind that the statutory structure is firmly weighted in favour of the local authority, which alone has the power to issue a public law application under Section 31 of the Children Act. He quotes Re N, intractable contact dispute, interim care order. The court cannot require the local authority to take proceedings. So the limit of the court's power is to direct the authority to undertake an investigation of the child's circumstances. So really, this is sort of referring to the legal context within which Section 37 operates, which is that under Section 31, subsection 1 of the Children Act, Parliament has entrusted to the local authority and not to the court the role of determining whether or not to make an application for a care order or a supervision order. And then again, the case of K regarding the boundaries of the jurisdiction of the court. So obviously there is this ability to make repeat Section 37 directions, but in each case and at each hearing, there is going to be a line beyond which the court may not go in deploying the facility that's provided for by Section 37, under which an interim care order may be made. Whilst the position of the line will vary in accordance with the particular circumstances of the case, the existence of the line and the need for the court to be aware of it should not be in doubt. So I think in my experience, there have been cases where the court clearly thinks that the local authority should issue, and they may repeat Section 37 directions, but there is a line beyond which the court should not really go. Now going to hand over to Rachel, who's going to talk to you about Section 38.
Thanks so much, Roshni. And just as I do so, we can see that somebody has asked a question. We're going to be coming to questions at the end of the webinar, and it looks, bearing in mind the time that we're on, that we're going to have a little bit of time to do that, so that's good. So moving on to the second section of the Children Act that we wanted to deal with in detail today, and that's Section 38. We're only really looking at subsections 1 and 2 because those are the ones that directly relate to Section 37 investigations. But to flag, this is where the power lies for the court to make an interim care order or an interim supervision order. And you can see from subsection 1B of Section 38 that it's where the court gives that direction for the investigation, for the report under Section 37, that the court has a permissive power to make an interim care order or interim supervision order in respect of the child that's being investigated into or reported on. And what the second subsection of Section 38 does is draws in Section 31(2), which will be very familiar to practitioners. So it's assessing whether there are reasonable grounds for believing that the circumstances with respect to the child in proceedings are as mentioned in Section 31. So that's your kind of quote unquote threshold of concerns that you're looking at, although I should be clear that the court will not have before it any threshold, and what the test or the threshold that they're looking at is reasonable grounds. So turning over to the next slide, on this same theme, the court will appoint a children's guardian at the same time as making that Section 38 order, unless it's satisfied that it's not necessary to do so to safeguard the child's interests. And that obviously has its advantages, certainly cases that both Roshni and I have been involved in, which hark back to that case of M referred to by Lord Justice McFarlane as he then was, of intractable contact disputes, of extreme hostility between the children. This can provide perhaps an accidental mechanism of having a separate representation of the child's interests as they would be in public law proceedings ordinarily. The second bullet point is exactly what Roshni was taking us through in terms of re-K, which is just emphasising that unless a local authority decides to issue proceedings, and that decision-making power rests with them, that's the intention and the will of Parliament, the interim public law order will be time limited, and it's time limited as specified in the order that's made by the court when the Section 31 direction is made. The standard time is 8 weeks, but there is some flexibility within the two sections we're talking about in subsection 4 to direct a shorter or a longer period. We flag up the final bullet point in this slide with a kind of word of caution, which is to say that an order of this kind, so a Section 38 order, can be used to remove a child from a parent where there is no good reason for obstructing contact, so preventing it from taking place. But the court has made very clear that this comes with a series of strong health warnings. So it's going to be a very unusual case where this is the mechanism that is used to remove a child from their parent. And certainly both Roshni and I have been before the court where the court has said, well, it's all very well asking me to direct this investigation under Section 37. It's all very well asking me to make an order under Section 38, but am I being asked to sanction removal? And of course, the answer is no. There's no application before the court. There's no care plan for what removal would look like. But that might be the type of case where you are making quite strict and expeditious steps to put the local authority, the designated local authority, on notice of the issues in these proceedings so that they can give very swift consideration to whether or not they need to be issuing proceedings if the court is contemplating the circumstances that might give rise to a removal. So that brings us to the conclusion of that slide. We wanted to flag up some key practical points. The first is perhaps an obvious one, but it can cause some furrowed brows when you get to the point of drafting in proceedings. So if a Section 37 direction is made, the local authority is not a party to proceedings. They should be invited to attend all future hearings, and their attendance needs to be reflected on the face of the order, but they are not a party. They're being invited to investigate the circumstances of the child. It's also important to keep in mind, in line with Section 37.3 and also that HPPB-OB case involving Croydon and the cost order, is the report that you have received arising from the Section 37 investigation, is it adequate? Does it cover the issues? Does it engage with the severity of the court's concerns? And this harks back to the need for clear reasons and clear information to be provided to a local authority at the point at which a direction is made. If the report is not adequate and the court still holds the same concerns it did when it made the initial direction, it may be that a further Section 37 direction is required, and that can be the reason for a repeat direction. The other thing to say, and it can seem a bit obtuse, is this third main bullet point. Many practitioners will be able to call to mind situations where a parent, in fact, wants the intervention of a local authority because they do not consider that any changes are happening and that the behaviour of another parent in private proceedings is extremely harmful. And both Roshni and I have been involved in cases of extreme emotional and psychological harm, which have not pricked the concern of a local authority, but should have done. And so there is a parent who wants the local authority to get involved and maybe to advise, befriend and assist under an interim supervision order, or maybe even share parental responsibility under an interim care order. So really this bullet point is about encouraging clients, when those public orders are made, if they are made under Section 38, to utilise the services that a local authority is under a statutory duty to provide. And in the slides that Roshni took us through earlier, you will note that under subsection 3B and C, the other thing a local authority needs to think about is there any service or assistance which they have provided or intend to provide to the child and the family, or any action that they have not taken to date or proposed to date. So it's quite a holistic analysis that needs to take place if they're not proceeding to issue proceedings. The final point on the slides that we've got for you today, after which we will have an amount of time for questions, is funding. So if an interim care or supervision order is made under Section 37 or under in line with a Section 37 direction under Section 38, public law now becomes a feature of the case. And what we would say, and having regard to various texts analysing costs and our own experience as practitioners, is that it's arguable that when the court makes an order for a local authority to provide a report under Section 37, the parents become entitled to non-means tested legal aid, which is obviously highly significant given the cuts to legal aid and therefore the limited class of parents or carers who are able to access legal aid for private law proceedings. So that's something to keep in mind. And also, if you are a firm that doesn't have a legal aid contract, ensuring that you're up to speed with advising clients of their entitlement to legal aid and thinking about referral onwards to different firms who may have a contract. So we have proceeded in a very focused and bite-sized fashion to bring us up to about 25 minutes, which was our intention, to make sure that we truly were giving you bite-sized information. I know we have at least one question, which we can have a look at now. And just whilst we're pulling that up, just to signpost to everybody that we are the second of 3 webinars, and the next one is next week on Wednesday, the 30th of October, and that's going to be a practical guide to support for parents in care proceedings, and that's going to be led by Imogen Meller and Jamie Cresland. So,
just looking at the questions. Firstly, to anonymous attendee, I'm sorry that we didn't actually see your message saying that you couldn't see the slides clearly. Apologies for that. I'm not sure what the issue was, but I hope you've been able to engage with the presentation. So another question, how often does the court give a judgment? More often or not, the local authority get the order and statements. Rachel and I did discuss this, and both in our experiences, this hasn't necessarily, well, the requirement for the court to give detailed reasons hasn't necessarily been followed in the cases that we've been involved with. And so that's something to think about moving forwards, because obviously it's very important to raise in court that the local authority are going to need to be, they're going to need to fully understand what the court is concerned about. But in our experience, neither of us have ever had reasons from a court. So in practice, it doesn't sound like it's necessarily happening in our experience.
We will circulate a set of, well, the set of slides will be sent out to attendees, so that hopefully will assist the two participants who raised that issue. And also for the question that Roshni just answered, that will give you the reference to the case law, which sets out that reasons must be required. And, you know, it makes sense, doesn't it, that if you have the reasons, the justification, the decision the court has made, then it's going to better inform the local authorities' inquiries and investigation. A question has been asked, could you please repeat the requirements necessary to determine the adequacy of the report? I think it's difficult to do that because the adequacy of the report is going to depend on the concerns that exist in a given case, and that's going to be fact specific. But having the detailed reasons will definitely assist with the court making sure that the social workers have adequately covered the matters in issue. And I think, you know, if it calls to you, you may want to have a look at that case of HB and PB, OB and the London Borough of Croydon, which is on the screen at the moment, because that identifies what wasn't properly done with respect to the allegations in that case. So the fabricated illness, I think I referred to it as fictitious illness earlier on, but fabricated illness is the correct expression. One of the things which was important in that case was about the specific training that was required to deal with the safeguarding issues for the children in that case, and that had not been undertaken, and that there was inadequate reasoning. So it's kind of, they're more generic analyses, and so you need to be quite fact specific. Anything else you want to say about that, Roshni?
No, I think you've covered that well. Okay.
Just looking at a couple more questions, which is helpful that those have come in.
So what are the circumstances that a child would be taken away under section 37? So if we're looking at legally how that could happen, well, by way of section 30, well, section 37, section 38 gives the court the power to make an interim order, such as an interim care order, and when making the section 37 direction. And it's difficult because in these circumstances, the local authority is not the applicant. They've not filed an application for an interim care order. They've not given the parents notice. They've not given them an interim threshold document setting out the concerns that they have, or a social worker's statement. So in that sort of scenario, because the local authority don't know that the court is necessarily making an interim care order or intends to, they don't necessarily have a care plan for removal. But I think the court may consider that the test for interim removal is met in those circumstances, and then therefore makes the ICO alongside the Section 37 direction. I personally have not had experience of that, and it sounds like it does raise issues in relation to the parents' Article 6 rights, because they're turning to court within private law proceedings. They've not necessarily had any idea that there could be a chance that their child could be removed from their care at those proceedings, and that the local authority would suddenly be involved and would suddenly have an ICO and be sharing parental responsibility for them, with them, sorry. So it's sort of a complex sort of situation. I don't know if you can add anything on that, Rachel.
I mean, I think all of that is absolutely right. And it's in some ways very similar to the answer that we gave in relation to determining the adequacy of the report. It's going to be an intensely fact-specific exercise, but ultimately, is the court going to be able to satisfy itself that it has run through the requisite criteria in the case law for interim removal without having any information from the local authority as to what other options the local authority has looked at before considering or putting before the court removal? No. So this may be one of those circumstances where the court is directing the designated local authority to be put on urgent notice of the Section 37 direction with absolute clarity and specifics set out as to why the court has those concerns. The court could list an urgent hearing requiring the local authority to attend so that they can address the local authority in respect of those concerns. But it comes back to that point that Roshni was making earlier on. The case law and the statute makes clear that the power to apply for public law orders is vested in the local authority, and the court can't compel a local authority to issue proceedings. So I hope that gives an answer to that question to a degree, but ultimately it's going to be quite a fact-specific scenario. We've had a question about funding, and we will answer that to the extent that we can. So this person is asking a very sensible, pragmatic question. If matters are consolidated, so presumably that's private and public law, and you have legal aid on a child arrangements order proceedings, but then cannot get instructions from your client for the public law proceedings, or applying for legal aid in the public law proceedings, how would you proceed? So, I mean, ultimately, the retainer only exists if you have the instructions in respect of that retainer. So that may answer the question quite straightforwardly. And it may be that a parent doesn't engage in order to proceed with an instructing solicitor when there's a shift in the kind of dynamic of proceedings, or when there's a different application before the court. So that's one part of it, but I guess the question is probably more getting at, and this is a guess from me, more getting at what do you do? Can you carry on your certificate? And this was a question that Roshni and I were discussing in preparation of this webinar, because ultimately when you're looking at an 8-week order, potentially, and that order lapsing after 8 weeks, many solicitors will carry on, and indeed in our cases that we worked on have carried on the same legal aid certificate, because the risk of applying for a different type of funding and then returning to the original certificate is too high, and they want to keep the client engaged. It's obviously a very pressured point in proceedings. So that has been the approach of solicitors we've worked with. And I hope that helps a bit on that question. Okay, another funding question. This question is about, sorry, do you mind if I carry on?
No, I don't know.
So this is someone saying, I understood non-means/merits legal aid is not available to a parent unless or until the local authority has issued an application, even if the court makes an interim care order/interim supervision order under Section 38 when making the Section 37 direction. Can I ask if you can clarify why it is arguable? The reason for that is, if you go back to the civil legal aid remuneration regulations, what it does, and I'm obviously talking to people who deal with this all the time, so please excuse the oversimplification, but it classifies family law proceedings into different classes. And one of the classes of proceedings for which it's a non-means but merits test is public law, and you have when you have a Section 37 direction and an interim supervision or care order, a public law component to your proceedings. And so that's what tips the balance. And so I think it is arguable. And obviously there's distinct advantages to that. I represented a mother in private law proceedings where she was privately paying because she didn't meet the means threshold. And at the point at which an interim care order was made under Section 38, my advice was make the application, and it was granted. And there was the disruption to the mother of changing solicitors, but there was a significant drain on her income, having to pay for the private law proceedings. And obviously the incursion into her private and family life occasioned by the interim care order, sharing parental responsibility for her children, was significant, and it seemed proper and right that she should have that assistance. So it's a question of arguability. It's certainly, if you refer to the costs in family proceedings textbook, it's certainly in there. It's something which is reflected in the remuneration regulations, and it's something that has practically come to pass. We're coming towards the end of time, and I've just noted the question at the bottom there. Will the making of an ICO, so an interim care order, automatically mean removal? Absolutely not. It never does. Whether it's a interim care order that's made subsequent to a Section 37 direction, or one that is made at the outset of care proceedings, that it's the test for removal has to be worked through. So there's no worry there. Anything else that you want to say, Roshni, at this stage?
No, I don't think so. Just that, yes, the court is only going to sanction removal if that high test is met. So it does not automatically mean removal if an ICO is made. I think that's all of the questions.
Looks like it. Thanks so much, everybody, and thank you for attending, and hopefully we've sufficiently engaged you that you'll come again next week, not to see us, but to see Imogen Meller and Jamie Breslin talk about a practical guide to supporting parents in care proceedings. And again, just to remind you that you're going to get a copy of the slides, and eventually there will be a recording once it's been tweaked to get rid of us staring into the screen at the beginning. But thanks so much for joining us. Really appreciate you all attending.
Thank you very much.